Under Article 1, Section 8, Congress may spend federal monies to provide for the common defense and the general welfare. Now, this is a fiscal power, not a regulatory power, and generally speaking, Congress has very, very broad authority to spend for the general welfare. If something is within Congress's contemplation as necessary for the general welfare, Congress can spend money to accomplish its objectives in that area. Now, probably most significant for our purposes and in general for federalism concerns is that Congress can use its spending power to provide money to state and local governments and to attach reasonable conditions that the states must comply with in order to get the money. And as it happens, this is an end run around limitations on the commerce power. Consider this. If Congress wants states to do something, and it can't tell them directly to do it, as in, for example, passing legislation under New York versus the United States, or maybe it wants the states to do something because Congress can't regulate it directly, because it's non-commercial in nature and intrastate, as in United States versus Lopez. Or maybe Congress just doesn't want to regulate in the area, but it wants it to be regulated by the states. What Congress can do is say to the states, look, here's lots of money, a grant and aid. Here's money for your highways or for your schools. But you know what? We will give you this money, but we'll make you adhere to certain conditions. We're going to say that if you want this money, you have to do the things we want. Basically, it's a bribe. Where you say, here, boy, come on, get this money, but you have to do this first. And the court has upheld the use of the spending power, this attachment of conditions, reasonable conditions, to get states to do what Congress wants. And it is, therefore, an end run around limitations under New York versus the United States or the Lopez case. And Congress has done this in many areas. It has gotten the states to enact rules about right turn on red, for example. Or right after Lopez, the Congress could have said, look, if you want education money, we're going to say you can't have this unless you pass a law saying that you can't possess a gun within 1,000 feet of a school and enforce that law. Now, there are some limitations, of course, on this use of the spending power. Again, as before, it can't be used to violate individual liberties. But more directly, the conditions that Congress impose must be reasonably related to the purpose for which funds are given. For example, Congress wanted the states to adopt 21 years old as the legal age for drinking. It didn't want to do it by a national law. It wanted to get the states to do it. So Congress said, look, if you want your federal highway funds, you have to adopt such statutes. So it made the states, as a condition of getting their money, adopt statutes that said you have to be 21 years old to drink. But how is the 21-year-old drinking age related to highways? Well, the court was very generous in that regard. It said, look, if states have differential drinking ages, you have situations where young people will get in their cars and drive to jurisdiction where they can drink and probably get drunk or inebriated, and then they'll drive home. This creates a danger on the what? A danger on the roads, on the highways. And therefore, Congress could reasonably connect up limitations on federal highway funds to drinking ages. But there is this requirement that the condition be reasonably related to the subject for which funds are given. Now, the third condition on the power to spend conditionally is that Congress has to clearly indicate, expressly indicate to the states that receipt of the money is conditioned on the states doing particular acts. If there's ambiguity about that and the state resists, let's say the state already has the money and now it's not performing this sort of condition and Congress says it should get the money back, the states will be protected, the court has said, unless Congress made it perfectly clear that it was a quid pro quo, that you had to do this in order to get the money. Okay, that's our selective run through Congress's powers. Now we'll turn to the relationship of the state and local governments to the federal government under the Constitution, more issues of federalism, and what we'll do is focus on what the states may and may not do under our constitutional scheme. Now remember, we said that Congress has to trace back all of its acts to some authority in the Constitution, because the Constitution creates a plan for the federal government, and Congress only, and the federal government only, has those powers that are set out by the Constitution. But it's different for the states. The states were already in existence at the time the Constitution was adopted, and they do possess, as I said, a police power to act for the general health, safety, and welfare of their citizens. So, under the constitutional scheme, what we have is a sphere of power for the federal government, which is carved out, but the states are left with all of the powers that they had prior to the Constitution being adopted, and it has all of those powers subject to particular limits imposed by constitutional provisions. So for the states, with respect to the Constitution, we don't look for sources of authority like we do with Congress. Instead, we try to find out whether there's some limit in the Constitution that bars the state's police power from being applicable. So we look for limits, not sources of authority. Now, a fascinating case concerning the reserve powers of the states came up fairly recently, a case of United States term limits versus Thornton, and it raised the issue about whether states could impose term limits on members of Congress by saying, in effect, that they can only run for Congress, be in the Senate or the House for so many terms. A whole variety of states tried to adopt these limits, as did the state of Arkansas, but Arkansas's limits were the ones that came to the Supreme Court. And in looking at the question of limits and whether states could put limits on it, the court said that basically putting a limit on how long you could serve, saying that you could only be an incumbent for so many years, was really putting an additional qualification on who could be a member of Congress to run for office. And the court said, and again we had a very divisive opinion in this context, 5-4, the court said, a majority said, that the Constitution itself establishes the qualification for members of Congress. We talked about this briefly in a different connection. It establishes age, citizenship, and residency, and that's it. And the court said, states can't add to these qualifications by, in effect, putting on term limits. The court said that that couldn't be done because it read the historical evidence as saying that even Congress, by mere legislation, couldn't add to the qualifications of office. Congress couldn't say, for example, that you had to have a college degree or something like that. And the fundamental principle here is that in a democracy, the people ought to be able to choose whom they please to represent them. But the question was whether states could add to the qualifications, not Congress. Could states do it? And the way this related to the reserve powers is that the majority said, at any rate, yes, we've created a federal constitution, and all the powers not granted to the federal government are reserved to the states. But, it said, the powers reserved to the states are only those powers that pre-existed the Constitution. And since electing people to Congress was a new right arising from the Constitution itself, that couldn't be within the reserved powers of the state. Now, there were dissents, and in a dissent by Justice Thomas, the dissenters, and particularly Justice Thomas, took a radically different view of what the reserve powers were all about. Basically, he said all powers not explicitly granted to the federal government, of whatever kind, are reserved to the states. And so states could add qualifications to the members of Congress when they were running for office. And with respect to the relationship of the states to the federal government and of individuals of the United States to the federal government, Thomas's dissent made a remarkable observation. Justice Thomas said that the ultimate source of constitutional authority is the consent of the people of each individual state, not the consent of the undifferentiated people of the nation. So for Justice Thomas, he views the relationship of the people of the United States as not necessarily a direct link with the federal government, but only a link through their states. And he thinks of the people of the individual states as an entity different from the people in general. But that view has not prevailed. In any event, for our purposes, we now want to look at what are these powers reserved to the states and exactly what kind of limits are put on the states by the existence of the Constitution and its provisions. Generally speaking, there are 4 kinds of things that states may not do under the Constitution. 2 of them we tend not to spend too much time on in our constitutional law courses, maybe because they're so straightforward. But just to mention them, first, states are forbidden expressly and specifically from doing certain things by the very terms of the Constitution.